বলুন না, ঘুমিয়ে
mentioning on a non-mentioning date when it has been assigned in the lordships that lordships will take mentioning only on Mondays and Thursdays. Under very compelling and constraining circumstances, I'm compelled to mention Can 6, which we have filed on behalf of the State Election Commission for release of EVMs, electronic voting machines, because the municipal corporation's terms have come to an end.
What do you want?
State Election Commission.
What do you want?
Release of EVMs.
Hey, why you are mentioning?
I'm wanting listing of praying for listing of CAN application number 6.
When has been the writ petition? What order has been passed?
The order was passed on the 23rd of February 2022, where lordships, where Honorable Justice Prakash Srivastav, and as his lordship then was, and Honorable Justice Rajshri Bhardwaj had directed
have
that.
You filed the application?
Yes, I have filed.
There's no such urgency, madam. Are you mentioning upon notice?
Yes, I'm mentioning upon notice.
Yes.
My lord, under compelling
Your lordships.
Under compelling circumstances, my lord, may I mention, my lord?
Why you are mentioning? We
My
have
lord,
fixed mentioning days, sir.
My lord,
For one day you cannot wait.
my lord, there is compelling urgency, my lord. My lord, I'm mentioning a PIL upon notice, my lord. My lord, this matter was supposed to come in monthly list of July, my lord. However, after that, this matter has not been taken up. However, my lord, in this public interest litigation, there was an interim order upon the Darjeeling municipality to ensure that no illegal construction is undertaken. My lord,
what do you want today?
My lord, urgent listing, my lord, of the.
What is the urgency?
My lord,
2022 order passed, suddenly you're coming?
My lord,
you are the petitioner.
My lord, I am the petitioner, my lord.
My lord, I beg to mention this matter, my lord. I am leading Mr.
Come on Thursday, Mr. Chatterjee. Yes, call the list.
My lord, in an extreme urgency, lordship, I am challenging an order of the Central Administrative Tribunal by which appointment of my all chief commission.
File it, sir. You get the certified copy and file it. What is the problem?
My lord,
have you applied for certified copy before the tribunal?
No, lordship. I understand.
Make your application, come and tell us. Yes, call the list.
It can be.
Your lordship, item number 1, Mr. Banerjee has requested if it could be passed over. Shotaru Banerjee. Short passover.
Mr. Banerjee means?
Mr. Shotaru Banerjee. He's appearing in this matter.
What did we tell you, madam?
My lord, on the last occasion, your lordship heard about the delay, your lordship, but not on the ground of the inquiry proceeding, my lord.
Have you filed your affidavits?
Your lordship, we haven't filed our affidavits because...
For 4 years you have not.
Your lordship, because the department, for the first time when I had informed them that this proceedings is there, they have learned that this entire WPCT is pending before your lordship.
So what? 2022 every what sort of excuse you give, madam?
Your lordship,
you are trying to justify again. The department changed, I changed.
Changed, your lordship. Written instruction.
Be humble to the court that this is the fact. Kindly give me this time. So we keep it in the supplementary dispositive. If they file opposition, very good. Otherwise, we are not extending the time.
Your lordship.
Your lordship, hear the matter not on merit.
Yes, we.
In item number 2, Lordship, I beg to appear on behalf of the petitioner, my lord.
I'm
It
for the
was
respondent
tagged
number
with
9 to
another
13.
contempt
I'm for the state,
application.
my
I
lord.
was requesting-
I'm for the state.
I'm for the private respondent.
My lord, in earlier occasion, one order, my lord. And one contempt application has already been preferred by that petitioner, my lord. We have come up with a fresh application, my lord. We have different persons, my lord. We have referred that the earlier order has been passed. So, my lord was in the view that both matter can be taken up analogously, and then after, my lord, this matter has been posted for today.
Look, the factual consideration.
What was the order?
My lord, may kindly come to my writ application, my lord. My lord will find from the page number 27 in my writ application, my lord. That one Binod Kumar Singh was preferred and writ application, my lord. That matter was moved
So
on
what happened?
5th 11,
PI has not
2013.
conducted any inquiry.
No, my lord, this order, impugned order was that, my lord, we directed the district magistrate Howrah to cause an inquiry in the matter, and in case it is found any illegal construction was made, he would see to that such construction is demolished and the water body is restored. Now, my lord, then after nothing had happened, my lord. That one contempt application has been preferred by this petitioner, my lord. This matter was also been taken up for hearing by today itself, my lord.
What taken out? Your contempt is barred.
No, no, my lord. No, my
2013
lord.
order.
Contempt is not barred, my
When
lord.
did you file the contempt?
My lord, I am not filed the contempt, my lord. I am not the petitioner in this matter, my lord. Only
May I-
referring
Then
this
who
order.
are you?
My lord, I am the someone else who have preferred a fresh writ application, my lord. This is my application, my lord. This is my public interest
What is the
litigation.
necessity? Proceed in contempt. The petitioner will
No.
proceed in contempt.
My lord, that is the,
My lord, may I
that is another writ petitioner is my lord involved. I am not in the earlier petition, my lord.
So what is your prayer here?
My prayer is, my lord, for the execution of that order which was passed by the coordinated bench of this honorable court, my lord, in earlier occasion, that 2013 order, my lord.
Who is for the state?
I'm for the state, my lord.
So yes, what is your instruction? What have you done?
Now, my lord, in this regard, I've got no instruction.
Lord,
as
I
yet.
have the instruction.
As
I
yet,
have
no
the instruction, my lord. I have the complete instruction. My lord, the writ petition, they are coming after 13 years for execution of that order. It is of 2013 order, one. Second, this petitioner moved the contempt application and wrote a letter to the authority that he doesn't want to proceed with the contempt application any further. That is the letter. He is not willing, and the contempt matter is perhaps gone into oblivion, my lord. Since then, 2014 contempt was filed. I request your lordship to take the second page. That is your lordship's order, second page, my lord. On 15th of December 2014, the petitioner in that writ petition wrote to the authorities that there was a mistake in the order. Plot number should have been 308, but based on a wrong plot number, that order was obtained. That he has mentioned. And he said that he does not want to proceed.
কন্টেম্পটে বলবে এখানে তার সময় কি সম্ভব
The first page itself, my lord.
ঠিক করলো না। Contempt.
I am representing in whose name the pond was recorded. Now, one order was passed by the state authorities for taking steps.
Now what happened? Water body has not been restored.
My lord, the situation has changed after 13 years. The water body has naturally, it has, I mean to say, died. It's
Let him come with the instruction. We will
only
take
one
that.
humble submission, my lord. He is coming for execution of an order of after 13
We
years.
consider that.
Yes. And my lord,
There is a plot number difference.
yes,
He will
yes.
come with a detailed report.
Yes, if your lordship kindly calls for the copy of the writ petition of this 32710, then it will be clear, because this order is pertaining to plot number 508, whereas the actual plot number is 308.
So what is the status of 308?
308 is completely a different plot number.
Who are you?
I am
You
my
are
mother.
occupying 308.
No. The pond belonged to my mother, whom I'm the legal heir of Angura.
You take instruction and come.
My lord.
Very well. May I file an affidavit, my lord? Because I need to place these documents. May I?
No, let us ascertain from the affidavit. If your statement is true, then we will not keep the matter pending.
Very good.
My lord, so far my petition is concerned, my lord, may kindly consider page number 23, my lord. I have mentioned the proper tag number, my lord.
Yes, but
I have annexed page number 23, my lord, the record of rights, and I made a representation, face representation, my lord, may kindly come to page number 40 of my writ petition, my lord.
yes, but order was,
Say, my lord, he cannot prove that the water body has now become Vastu land and someone has constructed.
he has come for execution of the order.
No,
That order
I have
is passed in regard with 508.
Others pairs also, my lord. In my writ
No.
petition, my lord, there are
The
other pairs
hardly
also.
learned advocates appear. Yes, next.
I'm grateful to your lordship.
For my lord, I am for the petition. My senior is online. Mr. Chatterjee will join us.
My lord, I'm appealing for the petitioner, my lord. This is the matter which has come for the 4 orders, my lord. Today, your lordship, on the last occasion.
Wait, Mr. Bhattacharya is here. Let us
Yes,
hear
my
him.
lord.
Mr.
Yes, my
Bhattacharya is here.
Let this matter, learned advocate general was supposed to take instruction and intimate the honorable court what would be the government decision.
Yes, Mr. Mitra.
Decision. My the instruction is
That OBC certificate.
yes.
Now, so far as I remember, that they were challenging the last paragraph of that memo of 14th of May.
Yes.
And they have no problem with the last paragraph of the previous page, which says that they can take steps in terms of the provisions of the Identification Act and others.
Yes.
So on that, your submission was that the last paragraph only says that if any it is found, may be proceeded with.
Yes.
So we want, this portion was the allegedly offending portion, for which Mr. Bhattacharya has asked for a stay of operation of that. That is his prayer.
Right. Kindly give me a minute's time. Yes. Now, my lord, so far as this paragraph is concerned, my lord, my instruction is that, my lord, it's completely, well, it's a verification. My lord, if somebody has obtained the certificate only on the basis of, my lord, the voter card, then, my lord, it would be verified and thereafter further verification should be held. Kindly come to the last paragraph page, my lord, if your lordships are, my lord, in WPA 300 or the other one.
No, it's okay, Mr. Mitra. You are placing the circularity.
Yes, may I read out? Moreover, caste certificates issued to the persons and dependents whose name have been deleted from the electoral roll of the state in the recently conducted SIR exercise shall be examined. Now, my lord, if somebody has, my lord, obtained this certificate on the basis of some other document, then, my lord, it's a different question altogether. If your lordships are pleased to come to the, my lord, requisite documents.
You are placing from the next matter, Mr. Mitra.
Or, my lord, I shall stick to, my lord, 300 only. My lord, if your lordships are pleased to come to my lord, page.
না না ঠিক আছে এটা কোনটা 275 হ্যাঁ
Page 22, my lord, of my lord WPA 300. Or your lordships are looking into the other, my lord.
No, it's okay. Then we take up 300. ওই 3 WPA 300 টা দাও। Mr. Bhattacharya is there, that matter also.
No, but
Yes, my lord, he is leading me in, one is my matter, my lord, which is the WPA 275 of 2026. Mr. Bhattacharya is leading me in that matter
Mr.
also.
Chatterjee, we are hearing Mr. Bhattacharya. Don't be anxious. You are not in court. You have anything more to submit, add to Mr. Bhattacharya's submission, we will listen to you.
Yes, my lord.
Yes, Mr.
kindly come to page 22.
Yes.
The guidelines. Now kindly come to my lord, page 23, clause 8. Requirement for obtaining a caste certificate. These are the requirements. The applicant must be a citizen. He has to be a permanent resident of West Bengal since such and such. He is an ordinary resident at the address currently residing. He belongs to the said category. She has claimed to belong to his identity, and the applicant does not fall under criminal. Then kindly come to 9. Eligibility criteria. Criteria in details. For citizenship, citizenship of an applicant may be ascertained from any of the following documents. Now, citizenship certificate, voter identity card, and then other authenticated voter list, permanent account number, birth certificate. Now, my lord, if somebody has obtained this certificate on the basis of this PAN card or caste certificate or birth certificate, well, the question of, my lord, his verification will not arise. Question of verification under that last paragraph will arise only in case, my lord, it has been obtained on the basis of the voter identity card. My lord, this is my instruction. I can file a short affidavit, my lord, to bring this on record, restricting to this. And that too, my lord, it is not, my lord, an absolute thing that, my lord, if somebody's name has been deleted in the SIR verification, my lord, his certificate would be, my lord, taken away immediately on that basis. If your lordships are pleased to come to, my lord, page 37 once again. Page 37. Lordships will find, my lord, that has been deleted from the electoral roll of the state in the recently conducted SIR exercise shall be examined.
But Mr. Mitro, this is not a ground for re-verification or for revisiting the issue in terms of Section 9.
Section 9 gives, my lord, what? If your lordship
will record, Mr. Mitro, that
Yes.
Mr. Bhattacharya has, we will say that we are not interfering with the regular statutory process which is provided.
Yes, that
But
is
Mr. Mitro, if the office, you are arguing that we understand, but the officers, Mr. Mitro, they will, it will arise to more prejudice to the persons.
I will tell you, lordship, my lord, why. My lord, I have wanted for these documents, my lord, they take time. My lord, I was told that, my lord, caste certificate, this OBC certificate has been granted to, my lord, people with surname like Ghosh Bosh. Ghosh.
Mr. Mitro,
Now, these are the complaints and
this condition that caste certificate pertaining to persons whose names have been deleted from the electoral would be a ground for cancellation subject to consideration.
Absolutely, under Section 9. This Section 9.
Mr. Mitro is not there in Section 9.
Kindly clarify, my lord. Kindly clarify that it says, my lord, as per the law, as per the extant act and rule mentioned above. Kindly come to that once again, my lord, page 37. Shall be examined and may be cancelled following the due process as per extant act and rules mentioned above.
সেকশন 9 যেটা sorry, we stopped you.
No. Kindly, my lord, come to page 37 once again. I'm sorry, my lord, troubling your lordships again.
No.
It shall be examined and may be cancelled following the due process as per extant act and rules mentioned above. Now that has been mentioned.
Mr. Bhattaji, that act is here, annexed. Identification.
এটাতে নেই।
Act is not annexed.
একটু যে-
মোটা মোটা
Act and rules দুটোই তো।
ও আচ্ছা হ্যাঁ act is there. আপনি খুলে পৃষ্ঠা খুলে
এই jurisdictionটা তো ভালো। এটার সাথে এটা বলিও তো
Sir, 8A and 9A are starts from there and then.
এই প্রশ্নটা statement করতে।
kindly come to section 9 once, my lord.
Yes.
If the certificate issuing authority is satisfied that a certificate under this act has been obtained by any person by furnishing any false information or by misrepresenting any fact or by suppressing any material information or by producing any document which is an act of forgery, it may cancel, impound or revoke such certificate in such manner as may be prescribed.
হ্যাঁ, it's okay. তারপর amendment to of the section 9. Certificate
Then subrule 2, subsection 2,
of section 2.
Yes, Mr.
subsection 2, notwithstanding anything contained in subsection 1, if the committee is satisfied, the committee, my lord, is under 8A. Committee is satisfied that a certificate under this act has been obtained by any person by furnishing any false information or by misrepresenting any fact or by suppressing any material information or by producing any document which is an act of forgery, it may issue a direction to the certificate issuing authority in such manner as may be prescribed to cancel, impound or revoke such certificate, and on receipt of such direction, the certificate issuing authority shall by order in writing cancel, impound or revoke such certificate. Then kindly come to 9A. Protection is there.
9A. কোথায়?
9A, Mr.
An appeal, yes.
9A of the rules.
No, the act.
The act.
Act, there is no 9A.
9A is not here.
Act is page 22.
9A is not there, Mr. Bhattacharya.
No, Lordship, look at the rules. Kindly come to the act.
Page 20.
Page
No, we are
22.
looking at the act.
Page 22 of the bunch.
Yes.
This is an act.
8A is there, but 9A is not there.
9.
There is no 9. 8A is there, then 9 is there.
8A, then 9,
8A is constitution of the committee.
and then 9.
9A is there. You're reading 9.
9A.
Now 9A বলছে তো সেটা confusion আছে।
9A is there.
ওখানে নেই।
8A and then 9, 8B, 9.
I think, Mr. Mitra, you are pointing out 8A. That is so.
No, after 9, my lord, 9A was, my lord, this is possibly prior to 2022.
Oh, what is 9A?
I shall read out, my lord. এটা থেকে বার করে একটা কপি অন্তত বার করে এটাতে আছে দেখো এখানে ফ্ল্যাগ করা আছে May I read?
I knew the latest amendment. Acting.
একটা যেটা আছে দেখো না আচ্ছা May I read out, my lord?
Yes.
Appeal against cancellation, etc. of certificate. An appeal against any cancellation, impounding or revocation of the certificate under subsection 1 of section 9 shall lie to the district magistrate or the additional district magistrate authorized by the district magistrate in this behalf. Where the certificate is cancelled or impounded or revoked, the subdivisional officer and to the Commissioner Presidency Division where the certificate is cancelled or impounded or revoked by an officer authorized under clause B of section 5 as the case may.
কত পেজ দেখাচ্ছে
আমি 1 মিনিট দেখছি আমার এখানে কপি দিয়েছিল
That is the appellate provision.
9 is the appellate.
No person as on date, my lord, has come forward before this court, my lord. I have taken instruction challenging any cancellation.
Yes, Mr. Bhattacharya, anything in reply you want to say?
Yes, that I have challenged the authority of the state to issue notification. That this is bad by the doctrine of dictation. Kindly come to the order of 14th May.
The entire memo is not under challenge. Mr.
Entire memo.
No, in item number first matter, the only that offending provision.
No, I am arguing the second matter before your lordship. Second matter, my lord, I am
No,
challenging.
we understood, Mr. Bhattacharya, you are worried about the last paragraph.
That is one, my lord, point of worry, but the entire thing, my lord, state government doesn't have any authority under the law.
But that is not the subject matter of challenge in the first matter. Kindly see the prayer of
Lord,
the first
kindly,
matter.
I am arguing both. Kindly takes up the second matter. The 30, item 30, which is being argued. Lord, the first one is, my lord, unfortunately, a truncated prayer. Lord, my basic challenge is, my lord, whether the state government by a general notification direct review from 2011. Lord, statute has given a specific power to a statutory authority to discharge his function. Lord, he can do suo motu. He can do on the basis of the complaint. But here that you have to revise from 2011, it's a dictation which is not permissible under the constitutional law. Kindly takes up the circular once again.
Then, Mr. Bhattacharya, you are complying, you are having no problem with one portion of the circular.
I have problem
that you
with.
have pleaded. That
No.
I have no problem if the usual procedure under section.
I say that the steps available under the statute will not.
That is available.
That's all.
Your interim protection which you are wanting is that you are including a fresh ground. You are including a fresh ground for in the last paragraph entitling the authority to go into the issue.
Probably, my lord, I am misunderstood.
No, you argued jurisdictional
But
aspect.
my basic point, my lord, that the state government, my lord, has no authority to direct.
That we will consider on evidence.
No, let them file
Maybe
affidavit. But in the meantime, my lord, this circular, my lord, should be stayed. Subject to.
Circular state
Subject
will go against your.
Lord, this is state subject to, my lord, the ordinary procedure to be complied on the statute. No, I have never said that there should not be any re-verification. If somebody, my lord, comes up with a prayer that X has obtained this, and that has been done in many cases. But that should not be, my lord, that it would be reviewed from 2011. Kindly see what is the social insecurity and the disturbance ought to be created.
Mr. Bhattacharya, in interim stage, you cannot pray for a final relief. You are saying that you start.
The final relief would be quashing. Milord, final,
Nothing we will consider, Mr.
Milord,
Bhattacharya.
therefore, I am not asking
But,
Milord, final relief. I am not asking Milord, kindly appreciate Milord. Probably I am really not able to communicate that the statute has empowered the method of cancellation. Milord, that process should continue, but that should not, that issue should not be done on the basis of the dictation of the state, that he do it from 2011. I am on that. And that is, Milord, one other is, Milord, the SIR.
do it from 2011 or 2005 makes no difference, Mr. Bhattacharya,
It makes a,
because ultimately, even if they pick up those cases, that has to be subject to the rigors of section of the Identification Act. So that issue, Mr. Bhattacharya, we will decide. But we cannot. You say that the power the conferred upon the authorities under the statute, you yourself have pleaded that I have no problem with that. But the entire circular cannot stay because there is a jurisdictional error. That stay cannot stipulate a particular cut-off date for that purpose. That, Mr. Bhattacharya, requires an adjudication upon merits. But whatever it is, even if they pick up certificates from 2011, it has to go through the rigors of Section 9.
Yes,
that, Mr. Bhattacharya.
My Lord, do the authority has any?
No, what happens, Mr. Bhattacharya, the entire circular is state. Your contention is that no, then there will be an impression that the authorities cannot take out genuine cases also.
That you clarify.
So that is, you are aggrieved by why you are calling from 2011.
My Lord would be pleased to, kindly excuse my Lord, impertinence. My Lord, pleased to observe that the authority will proceed bereft of and independent of this circular. What is the problem?
No, where is that? They have not said so.
Kindly read that.
Yes. They have not said that the SDO will not cause.
Kindly read that. Kindly allow me to read it, my Lord.
Yes.
What prompted, my Lord, the issuance of circular? Re-verification of caste certificate issued since 2011. Including those issued during the Duare Sarkar program, where statute has empowered that if anybody has obtained it by fraud and others, statute will take action. But you are dictating it. I have to go from 2011. Why this dictation? And then kindly also come, how this contradiction runs. This is done not for any administrative purpose. You are aware that 1.69 crore caste certificate has been issued since 2011. Such and such certificates, such and such have been issued by the respective certificate issuing authorities against applications received through Duare Sarkar camps in so and so. It is further stated that is certain second generation caste certificate might also have been issued, or presumption, on the basis of such certificates during this period. Now it has been observed that authenticity and genuine sum, you yourself is not sure, and you are saying that some certificates issued since have been challenged by different quarters. If they have been challenged, that is gone into by the statute?
No, we understand that, Mr. Bhattacharya, but it comes down to the point that exclusion will be on the basis of the statute.
Why should I be sent to this rigor, irrespective of any particular complaint?
That we will decide at the time of final.
This matter has been taken up on the.
Moreover, first matter is not, your prayer is not that.
Lordship, hearing the second matter too.
Yes, the second matter we will take up.
In second matter, my Lord, this is the specific argument that we have challenged the authority of this government. And when they say re-verification of such caste certificate, well, let it remain to the such. Why it should be, my Lord, omnibus? You yourself say that re-verification of such caste certificate at the level of the respective issue will be done. Well, such means, my Lord, he has a specific definite number on the basis of the complaint. And then you are therefore requested to kindly advise all these subdivisional officers. Therefore, this is dictation. SDOs don't receive any complaint or doesn't do it so moto. What this certificate is authority to re-verify all caste certificates issued since 2011.
Now,
if you say,
verification master, Mr. Bhattacharya has to pass through the rigors of Section 9. Your contention is that you cannot pick it up from 2011.
No,
you are saying from 2000.
I have not said that. I have said that if any complaint comes from 2005 even, that can be done. That is the duty cast upon the statutory authority. But here the statutory authority is directed that you have to do this. Whether, my lord, that dictation is permissible under the law. And you yourself, the government says that such certificates, and then you come to add another thing which is serious. Serious thing, the next page, moreover. Well, the moreover is an additional emphasis. Caste certificate issued to the persons and dependents whose name had been deleted from the electoral roll. When I had got the certificate, I had a certificate. Now, since it has been deleted, in the recently conducted SIR exercise, shall be examined and may be cancelled. Who is going to examine? How we can examine whether my name in the electoral roll was genuinely deleted or not? And then threat. Any laxity in this regard will be viewed accordingly. Personal liability has to be fixed up. The concluding line, any laxity in this regard will be viewed accordingly and personal liability of the issuing authority shall be fixed. Therefore, nobody will take the responsibility, everybody will go on without cancelling. Any laxity would be, how this threat from the higher authority comes to the statutory authority? Is it not hit by the doctrine of dictation at the very initial stage?
আসুন না দুটো একসাথে নিয়ে নাও। Involved in both the above writ petition Yes, Mr. Mitra.
Lordship.
You heard Mr. Bandyopadhyay.
Yes.
That-
May I, my lord, kindly take. On the last day, my lord, your lordships were pleased to, my lord, on 13th of August, your lordships were pleased to, my lord.
That paragraph 5 statement.
5 and
8.
5 and 8.
Paragraph number. Second page. A direction was given to avail appropriate instruction pertaining to the allegations. The last order.
Yes, yes.
My lord, if your lordships are pleased to come to, my lord, towards the end, my lord, the third paragraph, my lord, from the end. Before we take a decision on the petitioner's prayer for grant of an interim order, we direct to avail appropriate instruction pertaining to the allegations leveled. Now, my lord, I have, my lord, received instruction, my lord, that nothing has been done.
No such meeting was also held. No such meeting was held.
No. Now, may I proceed for the rest of it, my lord? Your lordships were pleased to keep, my lord, the point of, my lord, maintainability open. My lord, kindly take up the petition once.
Yes, Mr.
My lord, on the last occasion, I had placed before your lordships, my lord, kindly come to paragraph 1, or my lord, lordships need not, my lord, go to that paragraph, my lord, the petitioner before your lordship, my lord, is a practicing act. Then, my lord, kindly come to, my lord, paragraph 4, my lord, at page 4. The present petition raises issue of substantial public importance concerning the legality of the verbal directions issued by the respondent authorities to various places of worship for removal of loudspeakers, irrespective of their compliance with the applicable statutory and regulatory framework governing noise level. The impugned action as pleaded herein have ramification extending to numerous places of worship and members of different communities across the state of West Bengal. The petitioner therefore invoked the jurisdiction seeking to ensure that executive and police authorities act strictly in accordance with law and do not impose any blanket, arbitrary or extra-legal restriction upon places of worship without authority of law and without following the procedure prescribed under the applicable statutory and regulatory framework. Now, my lord, I had made 2 submissions, or I would make 2 submissions on this. The first one is verbal instruction given by the issued by the respondent authorities. Now, if your lordships are pleased to look into the cause title, it does not, my lord, appear, my lord, who was the authority who allegedly issued such instruction.
Such verbal directions.
Verbal direction, yes.
For that you are showing? Which page you are showing?
My lord, paragraph 4, my lord.
No,
page,
that we have seen. Cause
yes.
title you said?
Cause title, my lord, there is, nobody is, my lord, named there.
Oh,
Then, my lord, they say, irrespective of their compliance with applicable statutory and regulatory framework governing noise level.
You are
Paragraph 5.
Paragraph 4, my
Acha, acha. Irrespective of the count.
yes. Now there is not a single document annexed to the petition to show that, my lord, it has, my lord, anybody is complying with this statutory requirements. Well, what I'm trying to, my lord, indicate before your lordships that, my lord, the allegations contained in the petition are completely vague and unsubstantiated, on which no reliance can be placed. Then kindly come to paragraph 5, page 5.
Yes.
As per the information received by the petitioner from various imams, secretaries, and presidents of religious places in the district of Hooghly. No particulars.
Yes.
No, my lord, with greatest of respect, no imam, secretary, or president has come forward before your lordships to come and say that, yes, I am the person who has received this threat. And all this are affirmed true to knowledge. A petitioner who resides at Topshia affirms his affidavit, the petition as true to his knowledge. Then, my lord, may I go on? Paragraph 5. These meetings were attended by representatives from various mosques and temples within the respective jurisdiction. During these meetings, the said representatives were unequivocally directed by the police official present to remove with immediate effect the loudspeakers that had been installed on the tower and premises of their respective places of worship. At the time of issuing these directions, the police authorities failed to produce any order. No particulars. Then kindly come to the next, paragraph 6. The temple and mosque representatives present at the meeting specifically requested that copies of any relevant government order or other official communication forming the basis of the instruction be provided to them. Paragraph 7. Further, as per the information and understanding received by the petitioner, information and understanding received by the petitioner from whom I do not know. Paragraph 7.
Mr. Mitra.
Yes. Seven. Furthermore, as per the information and understanding received by the petitioner, my lord, from whom I do not know, this practice has not been confined to one locality. Rather, similar meetings and instructions have been reported as having taken place across various districts and towns throughout the state of West Bengal, indicating a pattern of action orchestrated by respondent police officials. In several instances, these directions for removal of loudspeaker have not even been communicated in person, but have been conveyed over telephonic conversation. Again, my lord, from whom the telephone is received, it's not disclosed. Allegedly received. Who was called over the telephone, not disclosed.
So your contention is no such threat was given, as you have said, and as such, no question of issuance of any formal order has not been made.
But today, my lord, the maintainability, my lord, I am on the point of maintainability. I said, my lord, this, may I place, my lord, few more paragraphs. I will not take, my lord, much time of your lordships. Then paragraph 8. Following the said meetings, police officials have been visiting the mosque on a frequent and regular basis and have been persistently insisting that the loudspeakers currently installed on the mosque towards the mosque towers be removed forthwith. No particulars. Which mosque, which officer visited? They know, my lord, that police officers are visiting. No particulars given. This ongoing and repeated application of pressure by the police authorities has not been confined to isolated or one-time request, but has instead amounted to continual and systematic insistence accompanied by an expectation of immediate compliance. So on third, according to them, my lord, the police officers hold meeting and give directions. In spite thereof, nothing is done. Paragraph 8. Then paragraph 9, committee members have been subjected not only to persistent demands, etc., etc.
Yes.
Lordship. My lord, kindly once, my lord, to cut short the matter, my lord, kindly once come to paragraph 17.
Yes.
Instead, temples and mosques are being threatened with punitive action and directed in a blanket fashion to remove or discontinue all use of loudspeakers.
17.
17, page 11.
Yes.
Instead, temples and mosques are being threatened with punitive action and directed in a blanket fashion to remove or discontinue all use of loudspeakers, irrespective of whether their conduct was actually in breach of any law. The widespread and systematic manner of such verbal and extra-legal enforcement, unaccompanied by any written order or due process, suggests an unwritten and state-level policy of arbitrary suppression, etc. Kindly come to the paragraph without marking. Photostat copy of a news article published in Indian Express newspaper on 7th August. Kindly come to page 137.
130.
137.
Hmm.
137 towards the bottom. The West Bengal police has urged mosques in various parts of the state to limit and remove the high decibel loudspeakers at the top and replace them with sound boxes. Following the police request, various mosques in the districts of Bengal removed loudspeakers. They are relying on, my lord, a report to say that, my lord, police officers hold meeting, give direction that remove everything. They rely on a report which says something else. Page 130, top. The move follows a decision taken by the newly elected BJP government in its first cabinet meeting to enforce existing noise pollution rules in religious institutions. The state police was subsequently asked to ensure compliance with the West Bengal Pollution Control Board's prescribed noise limits, such and such, in residential areas. This is the report.
Yes.
Now, my lord, on the last day, my lord, I submitted before your lordships that, my lord, vague allegations, my lord, on the basis of that, a writ petition should not be made maintainable. My lord, I heard that, my lord, I am a civil lawyer. The writ, civil law and writ law are different. That is what I understood, my lord. I tried to find out, my lord, what is the actual position. However, may I rely on a few decisions of this court as well as, my lord, some other court?
So, Mr. Mitro, subject to what you are asking, what we are wanting to know is that the noise guidelines and everything which has been provided pertaining to the earlier judgments, which Mr. Bandyopadhyay relied. So, if there is only an increase in the decibel limit, the police can take steps. But in this case, you are arguing that
sorry, yes,
that whatever provision, legal provisions are there, that will take its own, that will operate in the field.
Yes.
But on the basis of this, the entire.
On the basis of this, my lord, petition, my lord, no order should be passed. My lord, the petition is, in my respectful submission, is liable to be dismissed in limine. Of course. And, my lord, I will place before your lordships, my lord, decisions of, my lord, Supreme Court, my lord, which, my lord, speaks about the responsibility of a lawyer petitioner.
Yes.
Now, my lord, may I start with, my lord, first, my lord, a decision, an old decision of this court reported in 1983, volume 2, Calcutta High Court Notes, page 261.
So, Mr. Mitro, before you go to that, what is your response to his argument relying upon that judgment which has been annexed? That on the basis of the judgment, noise pollution issues pertaining to that guidelines were issued.
Yes.
And we have not violated. So what was the even if we admit, what was the necessity for the police to come inside and hold meetings?
Meeting, my lord, that is exactly what I am saying, my lord, that, my lord, the fact that there was a meeting or there were meetings, my lord, is not borne out from the petition. Now, mere, my lord, a bold allegation, my lord, saying that, yes, people have come to me and I have been, people have gone to so and so, not even named. The police have gone to Mr. X or unknown people and have threatened. Now, my lord, what is the value of that? Or, my lord, should the court rely on such allegations? Now, my lord, may I? My lord, may I first rely on a decision reported in AIR 1984, Calcutta 52? It is 1983 SCC Online, Calcutta, 150.
Position is well settled that writ court cannot go into an inquisitorial inquiry.
No.
Furthermore, where
Kindly, my lord. Kindly, may I place, my lord? I will not take, my lord. Kindly give me 15 minutes. I will conclude within that, my lord. Well, kindly come to paragraph 17 once, my lord. Paragraph 17. It has been urged by the learned senior standing counsel and the learned senior government leader appearing on behalf of the board and the state of West Bengal respectively that in the writ petition, no prima facie case has been made out by the writ petitioners justifying the issuance of the rule licence. Then kindly come to 18, paragraph 18. In our opinion, there is much substance to in the above contentions of the appellate. A writ petitioner is required to give all particulars and the basis of the allegations in support of the prayer for the issuance of the rule. A mere allegation without any material in support of the same will not entitle a writ petitioner to ask for any assistance from the court, for otherwise any unsuccessful candidate in any examination may file a writ petition alleging that the answer scripts have not been properly assessed, etc. Then, my lord, on such vague allegations unsupported by any material, the court will refuse to entertain a writ petition. It is, however, contended by the learned advocate appearing on behalf of the writ petitioners that as it is a public interest litigation, mere allegations will be sufficient for the issuance of a rule, and the authorities concerned will be required to produce all relevant materials and records to disprove the allegations. We are unable to accept the contention. Now, my lord, this is, my lord, what the division bench said, my lord, sometimes back. Then, my lord, kindly come to, or
Was this a public interest litigation?
yes. Next, my lord, may I rely on another decision of this honorable court reported in, my lord, 2018 SCC Online Calcutta 236. Particularly the so-and-so administration to implement its own transfer policy and to follow the office order dated such and such. Then, my lord, kindly come to paragraph 9. It is well settled that in a public interest litigation, the court has to be satisfied about the credentials of the petitioner and about the correctness of the information given by the petitioners. There should be sufficient materials and categoric averments in the petition to establish that the information given is not vague and indefinite. The information should show the gravity and the seriousness involved. Applying such propositions of law to the facts of the present case, we are of the opinion that the petitioners are not entitled to the reliefs as prayed for, and accordingly the writ petition is dismissed. Next one, my lord, kindly come to, my lord, 2026 SCC Online Calcutta 10086.
1086.
Yes.
Kindly give me a minute. Kindly give me a minute, sir. The present public interest litigation has been preferred by the petitioners primarily praying for issuance of necessary direction, etc. Then kindly come to 7. Petitions leveled in the writ petition are primarily directed against the private respondents who, according to the petitioners, have filled up land classified as pukur without availing necessary permission from the competent authority. Such allegation is not acceptable in view of the certificate of conversion pertaining to the land in question issued by the district land and so and so. In favor of the writ petition appears to have been preferred on the basis of vague allegations. In view thereof, no interference is called for. The present PIL is dismissed. Now, this was, my lord, or this is a consistent stand of this honorable court. May I, my lord, rely on two judgments of, my lord, other courts. The first one is reported in 2016, SCC Online Madhya Pradesh 2505. Again, a division bench judgment. It's really, my lord, very short one. Only one paragraph, kindly come to paragraph 4. Even though there is no dispute in accepting the aforesaid legal proposition put forth by the petitioner, but we find that in the writ petition, except for making vague allegations that there is large-scale illegality in the appointment, no specific material has been produced to say that in what manner and how the irregularity has been committed, except for filing certain paper reports and pointing that certain relatives of the members of the executive council have been appointed on contract basis. No sufficient material or prima facie case is made out for holding that there is irregularity in the appointment made. Accordingly, the writ petition or the petition is dismissed. And my lord, the last one, my lord, is a judgment of the Allahabad High Court, a very recent judgment. এটা কপি দিয়ে দাও কপি হ্যাঁ কোনটি kindly come to, my lord, the prayers are set out only one paragraph. Kindly come to paragraph 3. We have gone through the kindly look into the prayers, in fact, my lord. Issue writ of mandamus to issue forthwith a direction on all district police headquarters, etc., to immediately seize and desist from taking any coercive action, executing detention against individuals peacefully displaying portraits of the and removal of posters of certain religious leaders of Iran who are dear to the so-and-so community illegally. No specific instance has been given with respect to any house or premises where the posters may have been pasted or installed or removed, nor has it been demonstrated as to how it has been done. On such vague and general averments, a public interest litigation cannot be maintained nor proceeded with. If there is any specific cause against any such police person under the provisions, the remedy prescribed, etc., it's not required. আর আগে একবার এই 5-13টা দিবি 5-13টা ছোট্ট জাজমেন্ট আছে
Yes.
ওকে নিয়ে এসছি ঠিক আছে reported in 2005, volume 13, Supreme Court cases, page 452. List of
লিস্ট অফ বুকস দেওয়া আছে, ওটা দিয়ে দেবো। আচ্ছা ঠিক আছে, এখন দিয়ে দিন, ছোট আছে, নো প্রবলেম। এই যে
All right, we shall take it.
আচ্ছা
Yes.
থাকুন।
The High Court in the impugned order has made observations that the petitioner, who was an advocate, was a stranger and no relief could be granted at his instance. These observations seem to have been in the light of absence of proper pleadings in the writ petition. The writ petition in public interest was filed seeking direction against the state of Odisha for payment of compensation, etc. A perusal of the writ petition filed before the High Court gives an impression that it was filed merely on reading of newspaper without making an effort to find out any fact from the family. The learned senior counsel appearing for the petitioner submit that, in fact, the petitioner, who is an advocate of Odisha, made enquiries, went to the village of Pratap Naik and even wrote letters, including a letter to the court. Unfortunately, none of these facts are mentioned in the writ petition filed before the High Court, and for that reason, at the threshold, the writ petition was dismissed, observing that Pratap Naik himself could approach the court for relief, if so advised. Finding no infirmity in the approach of the High Court on the basis of the petition of the like which was filed, we, while dismissing the special leave petition, permit filing of a proper petition. Now, here again, my lord, the persons concerned, my lord, they have not come forward, my lord. The allegation is, my lord, that certain persons were threatened, they have not come forward.
Yes.
বলবৎ সিংটা দেখিয়ে দিন, বলবৎ সিং চোপড়। হ্যাঁ 10-3 কপি নেই তো, 10-3 আছে, 10-3 2010 ভলিউম 3 এসএসসি।
আর কত যাচ্ছেন?
পেজ 402।
টাইম নিয়ে চলে।
বই আছে।
On the same point, Mr. Mitra.
My lord, it's, my lord, the obligation of, my lord, the advocate petitioner.
And meant for the poor and the oppressed.
My lord, kindly come to 2010 volume 3 Supreme Court cases, page 402.
Yes.
My lord, kindly come to, my lord, paragraphs 29 onwards, my lord. Well, 29, the public interest litigation is the product of realization of constitutional obligations of the court. Kindly come to 31. According to our opinion, the public interest litigation is an extremely important jurisdiction exercised by the Supreme Court and the High Courts. The courts in a number of cases have given important direction and passed orders which have brought positive changes in the country. The court's directions have immensely benefited marginalized section of the society in a number of cases. It has also helped in protection and preservation of ecology, environment, etc. Then, my lord, kindly come to my lord, kindly come to paragraph 39.
Yes.
The original and evolution of public interest litigation in India emanated from realization of constitutional obligations by the judiciary towards the vast section of the society, the poor and the marginalized section of the society. The jurisdiction has been created and carved out by the judicial creativity and craftsmanship. In such and such, the court observed that Article 32 does not merely confer power on this court to issue directions, orders, or writ for the enforcement of fundamental rights. Instead, it also lays a constitutional obligation on this court to protect the fundamental rights of the people. The court asserted that in realization of this constitutional obligation, it has all incidental and ancillary power, including the power to forge new remedies and fashion new strategies designed to enforce the fundamental right. The court realized that because of extreme poverty, a large number of sections of society cannot approach the court. The fundamental rights have no meaning for them, and in order to preserve and protect the fundamental rights of the marginalized sections of the society by judicial innovation, the courts by judicial innovation and creativity started giving necessary direction and passing orders in the public interest. Then, my lord, kindly come to, my lord, directly paragraph 173. Paragraph 173. When we revert to the facts of the present case, lordship's got it. Page 459 of the book.
Yes.
Paragraph 173. When we revert to the facts of the present case, then the conclusion is obvious that this case is a classic case of the abuse of the process of the court. In the present case, a practicing lawyer has deliberately abused the process of court. In that process, he has made a serious attempt to demean an important constitutional office. The petitioner ought to have known that the controversy which has been raising in the petition stands concluded, etc. Then, my lord, kindly come to the next paragraph. A degree of precision and purity in presentation is a sine qua non for a petition filed by a member of the bar under the level of public interest litigation. It is expected from a member of the bar to at least carry out the basic research whether the point raised by him is res integra or not. The lawyer who files such a petition cannot plead ignorance. Then kindly come to one more paragraph, paragraph 181. We have carefully considered the facts of the present case. We have also examined the law declared by this court and other courts in a number of judgments. In order to preserve the purity and sanctity of the PIL, it has become imperative to issue the following directions. Then will kindly come to directions are given. Clause 3, the court should prima facie verify the credentials of the petitioner before entertaining a PIL. The court should be prima facie satisfied regarding the correctness of the contents of the petition before entertaining a PIL. The court should be fully satisfied that substantial public interest is involved before entertaining the petition. These are the, my lord, and one more, my lord, judgment, only one paragraph, my lord, from a judgment reported in 1988, volume 4, Supreme Court cases, page 534. Only one paragraph, my lord, and I shall stop, my lord. I said that I shall take 15 minutes. 88.4.
Para 13.
Paragraph 13, my lord.
Written?
534. Paragraph
13.
13, 1, 3. Split it in the writ petition before the High Court. As an abstract point of law, there was no reference to any material in support thereof, nor was the point argued at the hearing of the writ petitions. Before us also, no particulars and no facts have been given in the specially petition or in the writ petitions or in any affidavit, but the point has been sought to be substantiated at the time of hearing by referring to certain facts stated in the said application by so and so. In our opinion, when a point which is ostensibly a point of law is required to be substantiated by facts, the party raising the point, if he is the writ petitioner, must plead and prove such facts by evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the facts are not pleaded, or the evidence in support of such fact is not annexed in the to the writ petition or to the counter affidavit, as the case may be, the court will not entertain the point. In this context, it will not be out of place to point out that in this regard, there is a distinction between a pleading under the Code of Civil Procedure and a writ petition or a counter affidavit. While in a pleading, that is in a plaint or a written statement, the facts and not the evidence are required to be pleaded. In a writ petition or in the counter affidavit, not only the facts but also the evidence in proof of such fact have to be pleaded and annexed to it. So the point that has been raised before us by the appellant is not entertainable, etc. Now, my lord,
Supreme Court যেখানে পড়েছে environment related.
Yes.
And my lord, also my lord, Supreme Court also has said, my lord, if you have anything regarding this environment issues, my lord, you have to go before the NGT. It is the NGT Act itself, my lord.
Yes.
In any event, I am today, my lord, on the basic question of mental ability, in my respectful submission, on the basis of these allegations, my lord, the petition, my lord, should not be entertained and my lord is liable to be dismissed in living.
Yes.
Those are my respectful submissions.
Mr. Band.
One part is what is a public interest litigation, and another part is in a public interest litigation, how much facts and the evidence are required to be given. Is it 100% like a civil trial or criminal trial? My lord, the public interest litigation, as your lordship knows, my lord, I am not required to give the background. It was evolved by the court, Supreme Court, by nature. Supreme Court has felt it right from Justice Bhagavati's judgment, P.N. Bhagavati, that yes, time has come up that the public interest litigation should be there. A seared case is there. A seared case, no details were there. 1982. But in a public interest litigation, may I just submit to your lordship, it is not an adversarial system of litigation. It is rather if a grievances is brought, rather in a public interest litigation, the grievance, any cause of action is brought. My submission would be, my lord, it is the duty of the court to look into that grievance. Yes, there is a genuine grievance exist or not exist. And in that case, the court will not go by technicalities. This pleading is not there, that pleading is not there, it's not a civil court. That is, after that, what has happened? After the police officer has come, who is the police officer? Whether he turned into right side or whether he turned into the left side, no. In a police overt action even, lordships have not questioned who is the police officer has come. It is otherwise a police overt action. Who is that particular police officer has come? At what time he has come? what he was wearing, whether he has come by bus or whether he has carrying on the motorcycle. Grievance is that whether the police officer has come. Grievance is that the meeting has been held in a town outpost, not in the police station. It has been stated in a town outpost, and your lordship knows what is a town outpost. In Bengali, which we say is a phadi. This petition, my lord, your lordships have said why the imam has not come, correct? Kindly see your lordships rules. Rule 20. My lord, your lordships are issued a notification on 23rd August 2016, defines public interest litigation. Can I just hand it over this judgment? Your lordships have quoted that my lord's judgment, Justice Nishita Matre and Justice Chakraborty. Let me see. What is the definition of a public interest litigation? See, my lord, paragraph, yes, citation is, I will rely later on, 2017 SCC online Calcutta 899. Brojes Jha versus Union of India and others. See, my lord, on paragraph 14.
Paragraph
14. The notification issued on 23rd August 2016 defines public interest litigation as follows. But it is in the incorporated in the rule. Rule is not with me.
Mr. Bandhu, the paragraph 14,
14, my lord.
Oh, the quoted portion. Yes.
Yes. It is quoted. The rule has been quoted. Public interest litigation shall include a litigation, the subject matter of which is a legal wrong or legal injury caused to a person or to determinate class of persons. Paragraph 14. Now, can I read again? Public interest litigation shall include a litigation, the subject matter of which is a legal wrong or a legal injury caused to a person or to a determinate class of persons by reason of violation of any constitutional or legal right, or any burden imposed in contravention of any constitutional or legal provision, or without any authority of law, or any such legal injury or illegal burden is threatened, and such person or determined class of person is by reason of poverty, helplessness, or disability, or socially or economically disadvantaged position, unable to approach the court for relief and for redressal of which any member of the public, not having any personal interest. Repeated submissions have been made why the imams have not come. Repeated submission why the imams have not come. If the imam comes, then it doesn't remain within the realm of a public interest litigation. If any one of the Muslim community comes with a complaint that, my lord, because of the non-using of the loudspeaker, I can hear the azan, then it's not a remain within the public interest litigation. Personal injury.
Yes.
Therefore, why the imam has not come, who attended the meeting, they have not come. That's not the point. My lord, question is whether the police overt action has infringed the right. That is the question. Infringe the right or not? That, of course, is a constitutional question, not the civil question, law questions. If the parameter of a public interest litigation and a civil suit is same, then why do you take public interest litigation? Tell them that go and file a civil suit. Who has come, who has not come, who will come? The question is, my lord, with great respect, I submit to your lordship, whether a skeleton facts have been given. Not the full proof facts like a civil suit.
Yes.
Now, my lord, can I read just this social economy for which any member of the public not having any personal interest in subject matter presents an application for an appropriate direction order read of this code under Article 226. Notwithstanding anything in any appropriate case, though the petitioner might have moved a court in his private interest and for redressal of public grievances, the court, in furtherance of the public involved between, may treat the subject of litigation in the interest of justice as a public interest litigation. Now, my lord, what are the allegations? My lord, what are the submissions? Commission is, first submission is, this is a verbal instructions. I have said, I have written in this, both in the complaint. My lord, today also, the kindly see, no answer has been given to this letter 134, 129, 5th August 2026, District Magistrate Hooghly. Can I read it again, my lord? Kindly excuse me.
You have read it.
Read it. Now, whether any reply has come, no. Although the learned Advocate General has said that no such has been given. And as per the law of the Supreme Court, Advocate General is a part of the government. Supreme Court has said, the Advocate General is a part of the government. That then the government is saying no verbal order has come. But when I have written this letter 129, whether any answer has come from the district, no, this is incorrect.
Yes.
I will give the reply, all the questions. Thereafter, I will make another submission after meeting the whatever the points have been given and whatever the case laws have been given. Now, therefore, this is 129. My lord, I am not, my lord, I have already, Mr. Advocate General also have read today in the morning, paragraph 4, 5, all have read. I am not reading. Therefore, whether any case has been made out at paragraph 4 or not.
Yes.
Leave aside paragraph 5 and 6. This is the grievance, this is the legal point, this is the legal injury. Now, my lord, paragraph 5, I have said the meetings were attended, and that has also reflected in the letter. Now said that there is, kindly see the cause title. Police officer's name is not there. Kindly come to the cause title. Kindly come to the cause title. Page 2. Kindly take paragraph 5. Respondent number 5, the Commissioner of Police, Chandanagar Police Commissioner. Then 6, the officer in charge, Lisa Police Station. Then C7, the officer in charge, Srirampur Police Station. Then C8, the officer in charge, Bhadreshwar Police Station. That is not correct that I have not given the designation. There were at least 4 officers' names I have given it. Although the question raises all over West Bengal. At least this has been given. Now, my lord, I have pointed out to your lordships this. Kindly come to, very importantly, kindly come to paragraph 16, page 10. Now, paragraph 16, page 10. The petitioner has reliably come to learn that the aforesaid verbal deletion and coercive measures being undertaken by the respondent police officials are not isolated to the district of West but are enforced indiscriminately across the entire state of West Bengal. Multiple credible sources and reports indicate that throughout the state, police authorities are compelling numerous temples, mosques, and possibly other places of worship to remove the loudspeaker forthwith. These officials' actions are being carried out in a summary and arbitrary manner without any preliminary determination. Can you see? Without any preliminary determination as to whether the use of such loudspeaker has actually resulted in any transgression of the permissible sound limit or not. But my point is very short. I am entitled to use the loudspeaker within the permissible limit. No qualified personnel have been deputed to measure or assess the decibel level of sound emitted from such devices. How the police can do it? This is the aberration. Then, Millard, nor has any ascertainment been made by the competent authorities to determine any concrete infraction of the existing rules, notifications, or the circular dated 17th October 2023. I have submitted, again I am resubmitting that an unique procedure in the state now. No, it will said on the verbally, do it, no public notice, no public domain, nothing, and police will go and implement. This is my submission. Earlier also in one case I said so. Again I am cases in this case. Again I am doing it in one case before Justice Sampar Sarkar. A new practice has been born now, developed.
Yes.
Now, Millard, this is your lordship has seen. This is regarding this. I will not take much time on that. Now, let me tell your lordship the case laws, the judgments which have been cited, and I will cite. Now, first, I hope, Millard, what is my case about? I have said police has gone, threatened, you remove it. That I have said in the paragraph 5 and paragraph 8. Can I read it again? Not necessary. I have read it. This is the. I will show, if your lordship's permit, I will show one document. Police has gone and seized after the meeting of the case laws. Because that it was not there. It is 2009-15. No? 2009, volume 15, SCC, page 351. I have not much judgment. Paragraph. Kindly come to paragraph 33.
Paragraph
33. Even in a case, kindly excuse me, even in cases, forget about this blood pleading and etc. Any person has come approach to your lordships or not. Even your lordships after reading a newspaper can so much initiate the public investigation. It has been done here. Then at that time, whether it was an admissible evidence or not, whether complete facts and figures have not been given or not. Only one, sorry, Millard, before that, just excuse me, Millard, just excuse me. One page I could not show to your lordship, so I am coming. Just one page. Kindly excuse me. That is the page, my lord, that he has read it. Again, I am reading in my own way. That is, my lord, page 137. This is 138.7. Caption, leave aside caption. Caption is the creature of editor. The West Bengal police has asked mosques in various parts of the state to limit and remove the high decibel loudspeaker at the top and replace them with sound boxes. And sound boxes, I have already, Millard, cited the judgment of the Supreme Court on the other day. There's a direction that all manufacturers should manufacture the loudspeaker with the limited sound which has been given. The question is today whether the state of West Bengal that has been implemented. Can you remember? I will show that judgment again. That following the police request, various mosques in the district of Bengal removed loudspeaker. Next. The more following a decision taken by the newly elected so-and-so in his first cabinet meeting, the number second, police held meeting with the mosque committee. Therefore, today it is said no meeting has been done. That's also not correct. Police has held meeting with mosque committees in several days over the few days. According to those involved, committees were asked to replace rooftop loudspeaker with sound boxes. Urban development, so-and-so, so-and-so, so-and-so. Now, my lord, kindly come to next middle. However, some Muslim organizations question the manner of implementation. It is two parts. I am no manner of implementation.
However, where you already?
However, some Muslim organization, middle, must read then 138 middle.
Which paragraph? Oh, however, yes.
However, some Muslim organization question the manner of implementation. Nijamuddin Bishwas, General Secretary of All Bengal Imam and Mujira Association, told the Indian Express that mosque committees were complying with police requests but argued that enforcement should be based on measures noise levels. The police approached mosque committee and asked them to remove the loudspeaker. So many are doing so, but there should be a proper system to measure decibel levels at both mosques and temples. If the sound exceeds this permission, it should be reduced. The law prescribes noise. It does not say loudspeaker must be removed altogether. That is not the one part of the report. Other part of the report would be also if when they have placed it. Siddiqullah Chaudhary, the petitioner, the president of the West Bengal, the honest to answer, the court have put in sound limits. Nowhere it is written that mosques will have to remove mics. We will oppose this move by the police.
Very good, Mr. Bandhavata. This is there in our. You have answered that.
Pardon?
You have answered that.
No,
you said that
what I am saying, my learned friend has read the one portion of the report, but
yes,
other portions of the report has to be taken care.
Yes.
Which is not done. That's my case. That is exactly my case is. Now, question is, my lord, this is the statement. My lord, one thing is vague statement. Another thing is 100% proof statement.
So that you have argued, the grievance has to be concerned.
Yes.
Technically, it cannot be gone.
I am so grateful to you, lords. I am so grateful to you.
You have taken.
I am very sorry, my lord. I'm so grateful. Now, my lord, kindly see this judgment which I was reading. Kindly, my lord, take this. 2009, volume 15, SCC, page 351.
Yes.
Paragraph 33.
Paragraph 33. In a public interest litigation of this nature, it is not necessary for the court to abide by the strict rules of pleadings. And even it is found that the petitioners are busybodies, the court will discharging them could proceed to deal with the public interest litigation suo motu. In Nirmal Singh Khalun versus State of Punjab, this court held the High Court, while entertaining the writ petition, formed a prima facie opinion as regards the systematic commission of fraud. While dismissing the writ petition filed by the selected candidates, it initiated suo motu public interest. It was entitled to do so. The nature of jurisdiction exercised by the High Court, as is well known, in a private interest litigation and in a public is different. Whereas in the latter is inquisitorial in nature, in the former it is adversarial. In a public interest, the court need not strictly follow the ordinary procedure. It may not only appoint committees but also issue directions, so and so, so and so. That's not it. This is therefore, this is blood the Justice S.B. Sinha, the Supreme Court judgment. Next, my lord. Chief Justice. But they have cited the Bharat Singh's case. They have cited. That is 1990, 88-4. Kindly take this one. This is 2023 one High Court cases, Calcutta 484. 2023 SCC online, Calcutta 1496. Shubhendu Adhikari and another versus State of West Bengal. Shubhendu Adhikari at that point of time was the opposition leader.
Yes.
And number 2 was a lawyer. Mr. Torun Jetutiari in this case.
Yes.
Now kindly come to paragraph 16. Can I read it?
Yes.
Mr. Urunpukar's strategy used to say Mr. Bandyopadhyay, paragraph 16.
Yes.
With regard to the submission of Mr. Bandyopadhyay that the pleadings are vague, no evidence has been placed on record. Court cannot decide or media trial. Court cannot decide based upon oral submissions of advocates across the bar, etc. Have been noted by this court. But what is important to point out is that the present writ petition is a public interest litigation. The Supreme Court in Narmada Bachao Andolan case has held that strict rules of pleadings may not apply in PIL. However, there must be sufficient material in the petition on the basis of which the court may proceed. The PIL litigant has to lay a factual foundation for his averment on the basis of which such a person claims relief. The information furnished by him and should not be vague and indefinite. Proper pleadings are necessary to meet the requirements of the principles of natural justice. Even in PIL, the litigant cannot approach the court to have a fishing inquiry or roving inquiry. He cannot claim to have a chance to establish his claim. It was further pointed out that the technicality of the rules of pleadings cannot be made applicable vigorously. Pleadings prepared by a layman must be construed generously as he lacks the standards of accuracy and precision, particularly when legal wrong is caused to a determined class. The present public litigation is sequel to the earlier set of public interest litigation which were disposed of by common order day 13 June 2020.
Yes, Mr. Bandyopadhyay, we understood. Your grievance we understood.
Kindly read this, Milord. Bharat Singh has been considered there. Kindly see that. Just kindly give me, Milord. We find that in the public seeks to focus on the consequences which have been occurred on account of non-compliance of the directions issued in the earlier order. Similar. Same nature of cases is mine. And therefore, in our view, the court is well justified in entertaining the public and considering the matter in a wholesome perspective. So far as the decision of Bharat Singh case, which I cited that day, today they have cited now. Now, Bharat Singh case is kind of this same would be inapplicable to the facts. It was a writ petition challenging the validity of an acquisition on the petitioner's property by the state of Haryana under the Land Acquisition Act 1894 in the said case. An allegation was made that the application made by the Haryana State Industrial Developer is nothing but a so and so. The judge has been distinguished completely on facts. And it has said, and here in this case, who was that? Then opposition leader, responsible person.
Yes.
And one of the writ petition, one of the advocate. Even then, our High Court has said no. No break pleading. And continuation of the directions. Here also I am asking for the directions which were there. I am not asking anything new thing from your lordships. What I am asking, I am saying the strict compliance of that directions. And no one can interfere so long I follow the directions. If I don't follow, file individual cases, that will be sin. Nothing more than that. Now, my lord, next is yes, this judgment I have given to handed over in the morning for quotation. 2017 SCC online Calcutta 899. First to check. Justice Matre. Now, my lord, kindly see of that judgment.
Oh, 2007, 17
Yes,
SCC,
in the morning.
Calcutta 8 yes.
Kindly see, my lord, I am not required to cite so many judgments because after paragraph 14, my lord, your lordships have dealt with so many cases, right from Janta Dal, etc., one after another cases. I am not required to, my lord, I am just to make it short, I am doing.
Yes.
To paragraph 22. Just a minute. 21. 21, I have 21. So 21, kindly come to 21. After considering the, can I read? After considering the aforesaid judgments, in my opinion, it cannot be said that the petitioners have no locus stay to file the present. Moreover, it is now well settled that when the interest of the public is the foremost consideration, for filing a writ petition, the courts will normally entertain it. However, the courts would consider whether such a petition has been filed with an ulterior motive or with an aim to embarrass the persons against whom the writ petition has been filed only for a private reason. There's no private reason. It's because the petitioner is motivated by consideration other than for bringing to the issue so and so, so and so. Now, then paragraph 22. The argument of Mr. Bandyopadhyay that the petition is not maintainable because there are neither so and so in the nor has a cause of action has been fails to impress me. In DLF housing construction and Delhi so and so, the Supreme observed that it was hazardous to embark upon the determination of the points involved in writ petition. There may be a firm and adequate. Mr. Datta has argued that no success was done so and so. But all have been rejected. That's arguments. Then will it kindly come? Kindly come to paragraph 70. Paragraph 79. Article 226 of the Constitution of India is couched in a wide language so that the authority of the writ court is not confined only to issue prerogative writs. Such wide language is used to enable the writ court to reach injustice wherever it is found. The jurisdiction on Article 2 of the Constitution is expensive and extraordinary, and the same does not stand fettered to answer. Next, paragraph 80 is important. The expression public interest means a legal action, which is in it. This part was written by my Lord Justice Chakraborty. There are two parts are there of this judgment. This means a legal action which is initiated before the court of law for the purpose of enforcement of general interest of public. The technical misdescriptions and deficiencies in the setting out of the case title to be secret open to non-suit a party.
Yes.
Where foul play is absent and fairness is not faulted, latitude is a grace of processual justice. This is all my Lord Justice Chakraborty has said in this judgment. And here is in this case also Borges Jad, he was also lawyer.
Yes.
Next, Millard, now I have to distinguish all these judgments. Now I am just first, I will not take much time, kindly take it, Millard. First judgment which has been cited by him, 1984 Calcutta 52. Just take note, Millard. Not required at all, Millard. Yes. (1984) Calcutta.
Yes.
My Lord Justice Chakraborty raised, my Lord Acting Chief Justice raised the question whether this judgment is a public interest litigation or not. See, this is a mandamus appeal. This judgment in a mandamus appeal, not in a public interest litigation. And by the unsuccessful candidates challenging the selection process. Therefore, this judgment has no application. Then, my lord, kindly come to judgment. 1983 Calcutta 131 ki chilo? Oh, same. Achha, okay. Now 2016 SCC on agar ko dekho. 2026 SCC Calcutta 1086. But let me just, I will make it very, your lordships will understand what I want to say, where I am trying to distinguish. One judgment is sufficient. That's a 2010 3 SCC 402, which has been cited by them. Kindly see this judgment. Factually see. 2010, the judgment has been cited. 10 3 SCC 402, kindly come. Read this paragraph first. 402, kindly come to paragraph. 174 first.
এখানে দেয় এই বইটা নিতে হবে।
First read kindly 20. In the instant case, one of the petitioners before the High Court, can I read? Copy actually down, Judge Sahib.
20, paragraph 20.
Oh.
Yes.
See, in the instant case, one of the petitioner before the High Court is a practicing lawyer of the court. He has invoked the extraordinary of the High Court in this matter. It was expected from an honorable member of the Nobel Prize not to invoke the use of the court in a matter where the controversy itself is no longer res intriga. This was a question regarding the office of the Advocate General. There should not be more than 62, no? More than 62. And in UP, the Allahabad High Court earlier decided the points, Supreme Court has decided the point, no. This is not applicable in case of the Advocate General. Now let's see, to invoke of this court in a matter where the controversy itself is no longer is. Similarly, it is a bounden duty of the court to ensure the controversy once settled by an authoritative judgment should not be reopened unless there are extraordinary reasons for doing so. Now, but here my case is, once the point has been decided by this court, how a police can, by an overt action, can nullify the judgment.
Yes.
Then, my lord, 21. The High Court entertained the petition despite the fact that the controversy involved was no longer res intriga. This is a representative Chief Standing Council. Then, my lord, this is the main position. Kindly come to paragraph. 173. Kindly come to me at 173. I am making it very short.
Yes.
When we revert to the facts of the present case, that the conclusion is obvious that this case is a classic case of the abuse of the process of the court. In the present case, a practicing lawyer has deliberately abused the process of in that process. He has made a serious attempt to demean an important constitutional office. The petitioner ought to have known that the controversy which he has been raising in this petition stands concluded half a century ago by a division bench judgment of the Nagpur High Court. Therefore said, no, lawyers should not come with this.
Yes.
Factually, my lord, it is so distinguishable. And so far, my lord, paragraph 181 is concerned, there is no cold. The question is this, my lord, the court should prima facie verify the credentials of the petitioner before entertainment. Credentials is there. This petitioner has also filed 3 other writ petitions, PIL, earlier, which this court has entertained it. I have given the details of that. And another paragraph, prima facie is regarding the correctness of the contents of the petitioner before entertaining. Therefore, the correctness today before a lordship's court, the main question is coming, whether, first of all, is it really vague? Absolutely nothing is there. Or 100% proof statements have not been given.
Yes.
But in that case, what the court should follow the procedure, I have given the judgments. And again, I am repeating, my lord, this is a greater interest. My lord, this is my submission. But today, I will be seeking to file a supplementary affidavit, giving few details.
We have heard you, Mr. Bandhu.
I understand. I am giving.
Then you are bringing in a supplementary evidence. We are determining.
If your lordship decides today, finally, naturally, the supplementary affidavit will not be used. I am saying that if it,
Mr. Bandhu, we are under the impression we are hearing out.
no, I have no objection.
No,
I have no objection. But the queries which were there on the other day from your lordship, all these queries are answered in my supplementary affidavit. Police went there, seized.
New material comes in, Mr. Bandhu, then we have to again give it copy to them, then decide.
All right.
That is your choice. If you say that at this stage you want to use a supplementary evidence, then it will be decided.
Yes. With a smiling face.
No,
I understand. I am saying, if your lordship finally decides the matter, I am not filing. That I have said so.
Yes, Mr. Bandhu, we are deciding the matter.
Very nice. No problem. I have no problem. I am not filing it.
Yes.
I have concluded my argument. But there are only one thing. There are number of judgments have been cited by them. If I take one after another, then it will take long time. There are 10, 12 judgments have been cited.
Oh, you have.
But I am submitting there that all are factually completely different. In Madhya Pradesh, there is no ratio. Bharat Singh case has already been considered and distinguished by my Lord Chief Justice Sivagnana. Third one, that the judgment, this is what Allahabad judgment, no ratio. Others Calcutta High Court judgments also distinguishable.
Thank you. We pass our orders. 2 p.m.
2 minutes.
Again,
against reply.
No, the cases. The 1983 decision, my lord, which I cited, the division bench judgment, it's, my lord, it was submitted that it's FMAT. Now, my lord, possibly, my lord, in 19...
No, Mr. Bandhu said about 1984.
No.
84 Calcutta.
84 Calcutta, yes, sorry. 84 Calcutta, my lord, it is submitted that, my lord, it is FMAT, so it was not a public interest litigation. My lord, I had placed this part, paragraph 18. May I read out only one line? It is, however, contended by the learned advocate appearing on behalf of the writ petitioners that as it is a public interest litigation. Paragraph 18.
Yes, that is why I was asking my brother. Then this is a mandamus appeal.
At that point of time, this demarcation possibly in 83.
Oh, 83. No.
This demarcation was not there. It was not marked as, my lord, PIL or P. These markings were not there.
We pass our orders.
It was written mandamus appeals. Just read it.
That is true.
Mandamus appeals.
All right.
Yes.
The matter has been fixed, my lord. I have to argue, my lord. Next week, my lord, your lordship, I will take that. Other side is here.
Let us pass the order. 3 o'clock, I have a bench, and I never dismiss matters in the absence of the advocate. The present writ petition has been preferred. The present public interest litigation bracketed in short bill has been preferred, primarily praying for issuance of necessary direction upon the respondents to cancel the verbal
other points. Your Lordship has dismissed it on the point of locus or vague pleading.
So we have discussed the we have dismissed it. We have taken the entertainability point, the pleadings which have been made, and we have refused to interfere.
Fine.
Item number 7. বইগুলো তো বোধহয় লাইব্রেরির বই। Or in this matter, the state of the matter filed a report and supplementary report. Last order and last order is also fine. I am filing my exceptionary report and supplementary report. Section 2 report.
No, although I am appearing for the intervener, my lord, but a resolution has been taken by our bar association, my lord. I am appearing for the intervener. I have filed an application, my lord. But, my lord, we are bound by the resolution taken by our bar association, my lord. Today, my lord, kindly, my lord, excuse me. But we have already taken our resolution, my lord.
We will abide by this resolution.
Now, Mr. Misro, these remaining shops have been removed.
Everything removed, my lord. Only 3 temples, my lord, are there. They have been asked, they have informed us that they will transfer the temple from the existing place to a separate place. There is one hotel which is standing, my lord. That litigation is going on. Court stays there, my lord. In a separate proceeding, my lord. That's why only one, apart from hotel, everything has been demolished. 3 temples are there. Within 3 days, my lord, they will transfer.
We are taking steps, my lord. A place, alternative place has been, my lord, indicated, my lord. We are trying to, my lord, remove that temple, my lord. It will take some time, my lord. We are also, because we are here to, my lord.
Then, Mr. Dotto, what remains in this?
There's nothing remains in this application. It can be disposed of, my lord.
My lord, my submission would be, my lord, district magistrate, my lord, I have Brookcat, my lord, filing report, my lord. Filing report, my lord, totally, my lord. Filing report, totally incorrect picture has been given to your lordship, my lord. My lord, if your lordship send any person, the actual picture will be available.
What do you want?
My lord, no, my lord, demolition.
What do you want?
My lord, encroachers are there. Nothing has been done. Some stall has been, my lord, they are voluntarily removed. But your lordship send any person just now. Your lordship will find that the encroachers, my lord, one example I am giving, my lord. One example I am giving, my lord. My lord, paragraph 6, 6 of my application, of my exception. 6 of my, in my read application, I have categorically, my lord, mentioned the topography of the VIP road enclosed. But in the report, your lordship will not find that there are the encroachers.
Then you have annexed, you have used any opposition?
Nothing.
No, my lord, nothing.
In the topography, my lord, you have stated the right from, my lord, Uttaranga Golagata to, my lord, Koikhali. Well, there are Bajas Malad existing. There are Malad, several Malad promoters, Malad, Artswell, MLA Malad.
The ambit of your entire state of West Bengal. Then you are filing that all illegal construction should be
Not construction, only encroachments of the government.
for West Bengal.
Not.
Then
Well, only the right from Malad to.
is that case you have made out as
Well,
regards this portion?
Well, Your Lordship, kindly look into my writ application, Your Lordship, fine.
Or we will decide on merits.
In
It
writ
appears that you are a bit far-fetched. You want that since I have obtained this order, I will continue this proceeding
No,
indefinitely.
Malad, it is not, Malad, it is not my desire, Malad. I am fighting for the public at large.
I understand.
Malad, Your Lordship, if Your Lordship, Malad, if my statement is, Malad, found to be untrue.
Reasonable. One should be reasonable.
But I am,
You cannot insist for continuation of a proceeding for years to come.
but I am not,
To bring on subsequent facts that these are the pockets where further illegal authorization.
Malad, not subsequent.
Wish to do so, we shall also take it upon merits.
Malad, not subsequent facts. In my writ application, Malad, I have stated everything. But in the report, my lord, the state authorities, my lord, being a senior, my lord,
Your exception.
my lord, I have given. In my writ application, I have categorically stated. In my exception, I have categorically stated. That's why, my lord, I pray before the
In item number 8, my lord, I appear for the respondent numbers 9 and 10.
Where is the petitioner?
Moved a previous writ petition registered as WPA.
But you find on the earlier two occasions did not appear.
Did not appear.
As your lord.
Somebody appears tomorrow, you please. Not today, we have to. Next.
For the petitioner, my lord.
Item 9, my lord, I beg to appear for the respondent number 17 to 20. On the last occasion, my lordship was pleased, my lord, directed to serve copies of the reports filed by the municipality and my lord by the state upon the my lord petitioner and upon.
But you have not done so. Not given copy.
My lord, it is not on us. It was the direction on the municipality.
Acha,
We have received a copy.
The second thing, my lord, this morning, my lord, I had the privilege of hearing learned senior counsel, my lord, item number 6, public interest litigation and private interest litigation. While whether this is, my lord, public interest or private interest, my lord. Report that,
My lord, this is the second round of PIL we are having.
On one hand, you adopt resolution. On the other hand, when we go into the merit, you say that there is a resolution.
My lord, I'm not saying I want to do this.
Just now we face such situation. When we went into the merits, person said, no, my lord, today there is a resolution.
No. We want to move this matter.
First issue a resolution, you issue a corrigent.
Petitioner, municipality is here.
He's for the municipality.
But he's for the municipality.
I'm for the municipality.
Tomorrow. The statement, my lord.
But yesterday only we got the exception. Will give us 7 days time because it was supposed to be filed within 3 weeks. But last night it was
Opposition.
It is that egg throwing.
They have filed the opposition beyond the time limit.
Take it up next week.
Next
week. Yes. Manoj, can you whether it would be possible to take up on 26th?
26. Can you give us another date after that?
27, 28. 28th, my lord. 28th, 29th, 29th.
If you are coming, Mr. Manoj, then we do.
29th is holiday.
Saturday.
Oh, sorry, I am. But start hearing of the PIL on Saturday. But PIL will be hard on Saturday. All are public interest. I'm sorry.
Is any development?
Yes.
My Lord,
Mr. Bandyopadhyay, you have
Development is there, my lord, only that 61 persons have not been given. 61. Otherwise, nearly 1,200 persons have been given. 61 belongs to Arabic. They have not been given the appointment.
my Lord, may I file the reports, steps taken? The charts are given that those who could not be accommodated, their details are given.
একটু দেবে copy?
Copy এক্ষুনি দেওয়া যাবে না।
No, in total, how many were there? 1241.
Yes, but the number of vacancies furnished by the state was 1177, 1,177. Out of that, we did the counseling, and there were some absent candidates, etc.
So what was the difference? 1177. 1241 minus 11.
67.
67.
64. 64.
64.
So this, apart from these 64, all have been given.
My lord.
That have been given.
Now, the candidates who have not been
I will
given,
either appointed or recommended, whatever it may be.
recommended.
Recommended, no, some persons have been already appointed.
And Dr. Patra, so far as the 64, what you are thinking?
My lord, these 64 could not be accommodated because the state could not give the matching vacancies for these candidates.
Why? What is the reason behind that?
They couldn't find them. They were not available. I don't know who is.
Where is the Advocate General?
Your Worship, I am led by London Advocate General in this matter. I have been informed by his office that due to the relation he would not be able to appear today. May the matter be kept any day as per your Lordship's convenience, and we shall also go through the report filed by the Commission in the meantime.
আমার রিপোর্টে কপি দেবেন? আচ্ছা, আমি জেরক্স করে নেবো। বা স্ক্যান করে মানে ছবি তুলে।
Yeah, in those 1177, all the persons appeared in counseling.
I know we have called all, but there was some absence. We have given
Then why it is not adjusting me, Dr. Patra?
because those are in different subjects and different categories. It was not available. These categories are not available. Had it adjusted,
Where have you stated that the state has not given you matching vacancies?
PC. From start.
Mr. Bandyopadhyay, so far as your petition is concerned, we can dispose it of.
My petition disposed of, no problem. But the juniors are also there. They have filed their petitions also. They have requested me to.
Are you? Oh.
I am only one. That my client has got it.
Not wanting to leave you, Mr. Bandyopadhyay.
Mother?
They do not want to leave you. They are catch hold of you.
That is that. Miller, only one thing just I point out. Yes, it is not here. Miller, this is the report which was submitted by them on 4th September 2025. Not here. Miller, your lordships will not get here. 4th September 2025 report. In that report itself, they have disclosed the Arabic. That is, Miller, Arabic is the vacancy is count 1, 2. 80 vacancies are there, 79 vacancies are there in the Arabic. This Arabic, 61 persons have not got the appointment.
For whom?
We can give
for one.
For 56 candidates out of 56, 16 have been given appointment.
16.
1, 6. And the rest have been not been given, though vacancies are there. And this, there is one condition incorporated as per court's order that irrespective of SC, ST category, only subject is the condition, precondition for appointment. That is the condition given here. If Arabic, there is any vacancy in any school in the subject of Arabic, then I have a chance to be appointed there.
Yes.
So condition here is vacancy in the subject.
So what happened? In respect of you, 16 persons got the appointment. And the remaining persons are,
16 persons have not been called.
but they were recommended to
Yes,
particular
they are
schools.
recommended.
Uh-huh.
They should, yes.
They have
They
been
should have been
recommended.
No, for counseling, they have not been recommended.
After counseling, not recommended.
They have not been called for.
They have not been called for counseling.
For counseling.
Counseling, why you will not be called? You are within those 1241.
Yes.
Then you must have been called for counseling.
Only 16 have been called for.
Mr. Kindly take the total information.
16 have been called for counseling and appointment have been given. But remaining 40 have not been given up.
Can dispose of those matters where they have got the appointment.
Yes.
Then who is appealing?
But in item 9, my lord, all the applicants have been recommended and
one by one.
But
Can I will, in that case, I will not disturb your lords.
No, disturb us. We are
No, your lordships will not be disturbed.
Petition and other petition we will dispose.
No, that's the reason I am leaving. I am just telling, if I leave, then your lordships will your lordships will not disturbed by me.
We are never. From all the
Well, take it in a lighter note. Every time if I am serious, then it's very difficult.
Item number 9.
Item number 9.
Item number 1, Act 1 to from Siliari. Item number 1.
Disposed of.
Item number 1.
Item number 1 order लिखो the
and 15 are different matters. 2 to 7.
no, item number 1 was appearing with সেটা ঠিক আছে item number 2 is a different matter.
2 to 7 and 15 are different matters.
2 to 7 and
15.
আচ্ছা, then where will you file the report? এটা তো dispose of করে দিলাম.
8 is pending.
I'm led by Mr. Bhattacharya. Kindly, Mr.
আরে দাঁড়াও না, পালিয়ে যাচ্ছি না তো. We are waiting for you.
This is the report filed as per your lordship's direction with regard to item number 1.
আচ্ছা, তাহলে ওখানে লিখো ওই let the report as filed by Dr. Patrol
have been. Only 60 amongst those 61.
Then for it.
Well, may I just submit one thing?
10 item number 10.
10 I am for the applicant. Same. Same, my lord.
9
My lord, kindly just one indulgence, my lord. I'm just.
Sir, we are not hearing.
Okay, okay.
Very-
Not no. 11.
8 and 10.
11, 11.
Now, item number 9.
9, my lord, I am for the application.
9 year হয়ে গেল।
লেখো Mr. Bose, learned advocate, appealing for the petitioner's 14 no 14 টা থাকবে লিস্টে আচ্ছা 15
Complied with
No, different, my lord.
or different matter? Yes.
16 why different matter it is your contempt
Yes, my lord.
Contempt file.
you have not recommended
Not included in the panel, my lord, but despite being called in the interview, my lord.
then 16 who is in 16 রিভিউ ও থাক তাহলে ওই দুটো না কটা ডিসপোজড অফ ওগুলো অর্ডার করে দেবে আর এই বাদ বাকিগুলো নট টুডে
1, 9, 12.
হুম
And the rest matter are adjourned for the day.
yes item 7
It has been made on behalf of the state.
My lord, I am led by Mr. Bhattacharya. They have filed one affidavit in form of
which matter
in a review. That is not listed today. Mr. Bhattacharya is.
oh যেটা লিস্টে হয়নি that will take it and pass order
Now, I am just appearing and claim for the affidavit that has been served in.
are review your matter is here in the list
No, no.
then why you are saying
It was
then you have to mention when next day first yes next item 17 oh that is what happened
8 and
My lord, we have filed our we want to file our affidavit.
where is Mr. Dhar
I'm being led by
petitioner nobody is appearing
Adjourned.
বলো 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 আমি বলছি
My lords. My lords, kindly,
দাঁড়াও দাঁড়াও এটা শেষ করো
oh আচ্ছা
May we file, my lord, the affidavits of compliance, my lord? I'll just indicate what had happened.
oh we know what had happened
those matter
Thereafter, my lord, there was a bridge.
now you are compliance is in which matter
Both the matters.
same issue.
so when we take it up next day we will take your affidavit today they are
My
not appearing no?
my lords, the rest of the contempt, when will be the next date?
Wait, yes, what do you want further?
no no
You want to mention what?
no next day these matters will be taken up on the
No,
next
we are asking you, what do you want from us? Have you not understood?
no the next date I could not follow, my lord.
Date will not be given, it will appear in the list. You have to keep a check on the
Very well, my lord. Will come. On the next day we'll submit. Very well.
Yes, anything else you want to say? Anything else you want to say?
No,
Yes,
that
yes.
is regarding those 61 Arabic vacancies. I will make submission on the next day.
Yes.
Yes, next item 19.
May it please your lordship, my lord.
File the affidavits on the next occasion.
আচ্ছা দিয়ে দাও দেখি 17 ফাইলটা দাও একটু
17 একটা ইনস্টিটিউট একটা স্টুডেন্ট দুটো কন্টেম্ট আছে
আচ্ছা
We are appearing, my lord, for
all the contemners.
all the
contempt,
আচ্ছা
alleged contempt.
Mr. Bhattacharya, petitioner no one is there.
No, my lord, no. Today, my lord, no one is there.
আচ্ছা লেখো Mr. Bhattacharya learned advocate appearing for the
in all of this was by going through the live stream of your lordship's last proceedings. I still haven't gotten all the pleadings as of yet. I only need a week's time, my lords. I'll come back prepared next week and I'll argue out the matter in totality. I'll finish my submissions.
But one more thing, my lord. During the submission of Mr. Galib, I want to rely on one more decision, only one, on the point of delay. I have already submitted by a letter to the state that I will rely on this judgment by a notice. So, my lord, next day I shall file that one-page note and the decision.
Then let that judgment also be served upon the
Judgment, it's a reported judgment. At a copy diyo to na number ta jene na.
consider that. I'll consider that and make my submissions as well on behalf of the state.
You were led by any person?
We were just informed right now that
Mr. Nilanjan Chatterjee, I think, my lord, who is a learned senior.
We don't know, Mr. Mantha. Make up your mind. We are thoroughly.
Absolutely,
This matter we have heard. We wanted to certainly on the last day these happened. So you take 7 days. You take time, but you come back ready and argue and
Lordship
finish.
gives me 2 weeks because I have just been informed that Mr. Nilanjan Chatterjee is leading me. Till yesterday night, I was under the impression that there's nobody leading us. Maharaj will just give me 2 weeks time. I will prepare, and if there
We will
is,
be sitting tentatively after 3 weeks.
I'll come back then and I'll
Till you come and make any prayer for adjournment.
no, I will not make it. Maharaj will make it peremptory. Your Lordship records my submission to that effect. Your Lordship makes it peremptory. I'll make submission.
এই শোনো যেদিনকে নেক্সট দিন বস see any order in this.
A direction may be given, my lord. Otherwise,
What direction will give, sir?
my lord, they appeared and, my lord,
দেখি ওই ফাইলটা দাও তো।
And KMWS
These are parted or assigned matter.
Pathad and as well as assigned.
ওটা কি দেখেছো চেক করেছো অ্যাসাইন কিনা? Not to decorate it. চলো তো। আজকে কি রিভিউ?
Review.
নেক্সট ওয়ান রিভিউ। ডাকো ডাকো। না ওইটাতে কি একটা অর্ডার পাঠাট করা আছে তো। এই 22 কে আমাদের রিভিউ ম্যাটার, আমাদের অর্ডার।